Well, first, welcome all of you to the Milken Institute today. For those of you who haven't been here before, we welcome you for the first time, and for those of you who are regulars, we welcome you back. We're going to have, I think, a very good session today, and it's going to be particularly interesting. Yeah, I turned it down a bit. I think you got me good now. Is that better? Still have kind of an echo. So can the sound man turn down just a bit? Better? Better, better, better? A little bit better? A little lower? A little lower. Use the mic. Is that better? Good, thank you. So all of you are clear that I've got no future in the sound business. All of us who are interested in public policy today are so used to dysfunction and lack of courtesy on the left and on the right. But I know that today is going to disprove what we see elsewhere. We have two exceptional people, both with very different points of view about an incredibly important subject, and I want to introduce them to you today. So with us first is Susan Herman. Susan is the author of the book that Mike referenced, Taking Liberties, the War on Terror and the Erosion of Democracy. And Susan, if you hold up your book so everyone will see it, it's available over on the desk at the end of our meeting. And as I said to John Eastman, if John has a book to talk about, we welcome his discussion of that too. Susan is the Centennial Professor of Law at Brooklyn Law School, where she teaches constitutional law, criminal procedure, and related subjects. She's written and lectured extensively on civil liberties, terrorism, and other matters involving constitutional concern, and she's been involved in a lot of important litigation in her life, including before the U.S. Supreme Court. And she appears regularly on PBS, C-SPAN, MSNBC, and NBC, where she's a regular on the Today Show. Susan's a graduate of Barnard College, NYU Law School, and served as a clerk in the Second Circuit for the U.S. District Court of Appeals for the Second Circuit. So please join me in welcoming Susan. Thank you for joining us. So when we knew Susan was going to come, we asked Susan to suggest a worthy opponent, somebody who she respects, but who would have a very different perspective on the issues that she covers in her book. Susan's recommendation was John Eastman. John is the Henry Salvatore Professor of Law and Community Service at Chapman University School of Law, where he served as dean from 2007 to 2010. He's also the founding director of the Center for Constitutional Jurisprudence, a public interest law firm. John's a well-known conservative scholar who clerked for Clarence Thomas on the U.S. Supreme Court and for Michael Ludwig on the U.S. Court of Appeals for the Fourth Circuit. He practiced at the prominent law firm of Kirkland & Ellis. He's participated in numerous cases of constitutional importance, testified before Congress, and regularly appears as a commentator on C-SPAN, PBS, Fox News, NPR, and many of our local California radio outlets. He also, by the way, for those of you who are locals, regularly debates Herman Chemerinsky, who is the dean of UC Irvine Law School, again, somebody who would more be in Susan's camp. John is a graduate of the Law School of the University of Chicago, Mike Clouden's alma mater, and has a PhD in government from the Claremont Graduate School. So please join me in welcoming John. So before we get to the discussion of the issues that we want to talk about and that Susan raises in her book, I really want to understand a little bit more about the two of you, and I think it's interesting for all of us to kind of understand how both of you got to where you are. Two obviously extraordinarily bright people, well-educated, et cetera, but with very different points of view on the subject. So this is a question about personal narratives. Susan, with all the things that one could have done in life, what interested you about civil liberties, constitutional rights, et cetera, that got you to law school, to the space you are today, to the presidency of the ACLU?
It's a great question. I mean, part of why I wrote my book is really full of stories of people, so the narrative is something I welcome. I guess, I've thought about that question some, and I think that in some ways our values are formed when we're quite young. So thinking about it, the earliest I can trace back my civil liberties leanings was third grade, when I went to a public school on Long Island in New York, where it turned out that the library had a boys section and a girls section. And I always thought that was just advisory because, I was reading my fairy tale books and the biographies of Clara Barton and the things they wanted me to read. But one day I wanted to take out Johnny Tremaine because we were doing that for our third grade school play, and I was told I wasn't allowed because it was in the boys section. So I went home and I told my mother. And what was extremely interesting to me about this was that steam came out of her ears. And so she went to talk to the librarian, and she told the librarian in no uncertain terms that I should be permitted to read any book I wanted to read, no matter which section it was in, and what was the library doing anyway. So, this was really my first view of perhaps authorities being well-meaning might want to make choices for me that maybe you could talk back to them, and maybe they shouldn't be making my choices for me. So there are other answers too. I had a professor in law school who really kind of got me directly into the Civil Liberties Union. But I think that was just my sense of how the world worked.
And John, I assume you would have backed the librarian.
No. I've got similar stories from the third grade as well,
okay.
In fact. But
so tell us a little bit, John, about how you got to where you are.
I remember in college being in a class about Thomas Jefferson, and I'd always planned to go direct to law school after college. And Jefferson writes a letter to his nephew. And his nephew asks him, what do I need to do to prepare for the law? And he says, before you approach the law, you need to read Locke and Hume and the political theorists. I ended up going to get a PhD in political philosophy instead, and then made my way back to law school, and particularly specialized in the time of the American founding. And so what brings me to this particular issue is those wonderfully rich historical records. We were rightly rejecting an overreaching government in King George III, and the litany of claims of abuses in the Declaration of Independence, in many ways tracks some of the stories in here. But then we experimented with a government that didn't have an executive at all, and it was a disaster, and it almost cost us our survival. And so bouncing back a little bit on that pendulum swing where we talk about secrecy and dispatch in the executive, particularly in times of war, I think is an important counterbalance to the original impetus of all legislative and no executive authority whatsoever. And so trying to find that balance is something that's been with us ever since the beginning of the Republic.
So most of what we're going to talk about today, and by the way, what we're going to do is spend some time talking on stage. I'm going to encourage questions later. Let's hold questions until the first part of our discussion is over. But most of what we're going to be talking about today is the world after the terrible events of 9/11 and after adoption of the Patriot Act. But I think for those of us, and I include myself in this, who really aren't constitutional experts, in order to really understand what happened post 9/11, we have to understand a little bit about the lay of the land pre 9/11. So I'm wondering whether maybe both of you, Susan, starting with you, but both of you could give us a little bit of perspective on, obviously not an entire constitutional law class, but kind of, what are the key considerations in the Fourth Amendment that were implicated by the Patriot Act? What was kind of the state of, maybe the state of even disagreement between guys like you before all this happened 10 years ago? And then let's take it forward.
I think that's a great place to start, because a lot of the things that people were concerned about in the Patriot Act as to the surveillance provisions, which is where the Fourth Amendment comes into play, a lot of those were already trends before 9/11. And a lot of what's happened to the Fourth Amendment, in my view, has really been incremental. So starting with the Fourth Amendment, not everybody knows that that's the part of the Bill of Rights that says that the people have a right to be secure against unreasonable searches and seizures. And there's more words that I think we don't need for right now, because that would be the whole con law class, which we don't want to do. So the basic idea of the Fourth Amendment was the framers put this in because they didn't like the idea of the government, the king's agents, just being willing to search their homes, find out what they were thinking, what they were doing, just at the drop of a hat because they wanted to. They believed in a certain kind of privacy, and I think it's an intellectual privacy as well as a physical privacy, because I think the idea of the Fourth Amendment, like many provisions of the Bill of Rights, is that people have to have a private enclave where they can think their thoughts and where they might oppose what the government is doing. And the government can't just reach in at any point and try to find out what people are doing or arrest them, because that power, that level of power, one of the sort of Fourth Amendment phrases is it invites arbitrary or discriminatory enforcement. There's always a danger that the government might be trying to target its political opponents, or doing some sort of profiling, selecting people because of their religion or whatever. And it always seems to me that the framers took this very seriously, because they themselves were revolutionaries, a number of them. So they had seditious literature in their homes, which the king wouldn't have liked them to have. And maybe some of them had the rum or tea on which they hadn't paid duties. So, today, a lot of people look at, the Fourth Amendment as, oh, it's a right of criminals, and that's not me, that's somebody else. But I think the framers took this very seriously, and getting a Fourth Amendment into the, as part of what was governing our lives was one of the major purposes of the Revolution. Okay, so that's the 18th century. Let me just, in 1 minute, just jump to, the 1990s. Because even before the Patriot Act and 9/11, the Fourth Amendment was already on the ropes. And it was on the ropes not from the war on terror, but from the war on drugs. And there were all sorts of cases in which the courts had watered down what I see as the sort of essential paradigm of the Fourth Amendment. And I think it would be helpful just to lay out two concepts of what the Fourth Amendment default is, what it usually requires, just as a kind of a benchmark. One idea, the words also mentioned in the Fourth Amendment, are that before the government can search your home or arrest you, they have to have, the general term is probable cause. But the basic idea is they just have to have a good enough reason to be suspicious of you. They can't just search your home because they're fishing. They really have to suspect you of something specific. One reason why they have to suspect you of something specific is there's this idea of particularity. They're only allowed to search in the place where the thing they're looking for could be, and they're only allowed to arrest the person they have probable cause to arrest. So that's one concept. There are a lot of exceptions, but that's sort of the default, the norm. The second concept is the idea of the judicial review, so that before the government is allowed to come into your home and search your home, they have to go to a judge, a neutral and detached magistrate is sort of the Fourth Amendment terminology, and they have to convince the court, the judge, that they do have probable cause or whatever is required. So that's the second idea in the Fourth Amendment. One is the government has to have some sort of particularized suspicion. And the second idea is they have to be able to convince somebody neutral that they really do have enough basis to be suspicious of you to justify the search or the arrest. And then the judge will decide whether or not usually to issue a warrant, but there's judicial review. So before 9/11, there were already all sorts of exceptions that the court was creating to both the probable cause requirement and the judicial review requirement. So the Fourth Amendment was already, had holes blasted all over it.
So, John, do you buy that? Does Susan have it right, or?
I'm not sure I'd accept the holes blasted all over it. There were a number of exceptions that the court had recognized, but I think not even relatively recent. Some were recent, but some were very long-standing exceptions. And the biggest exception that I don't think she talked about, but I think is going to be part of the theme of our general disagreement, is most of that applied in the criminal context. Those kind of requirements were never thought to apply in the war context. And I'm reminded of a wonderful story from my own family history. My grandfather enlisted at age 17 to fight in World War I when we entered the war. He was underage, so registered under an assumed name so that he could get over there and fight. He ended up being an ambulance driver. He didn't fight, but I wanted to build a history about his time there. And of course, since I didn't have the name that he had enlisted under, it was a little hard to dig out the records. And my great aunt had a set of letters from him. I thought that'll be perfect. There'll be some reference to that about what the name is or what his station is, and that'll be enough that I could track this down. And I opened up the letters, and it was like a paper doll set. I mean, the censors had chopped up the letters so much, and this was a letter from an American citizen home to his own sister, and there was no judicial warrant. There was no oversight. There was no, and the understanding was that we had to do this in order to prevent you from inadvertently writing something about your location or where you were going to be going next in case your letter got intercepted. And nobody ever thought that raised a Fourth Amendment issue because we understood that the Fourth Amendment was there to deal with the criminal context, that in wartime, all sorts of things that we come to expect in peacetime don't exist to that same degree, that we shift the balance rather dramatically because of the larger consequences of not getting it right. And it's that swinging pendulum that always takes account of the circumstances. And to use the language of the Fourth Amendment, what we mean by reasonable, and the court has said this, I think rightly, over and over again, what we mean by reasonable may be dramatically different depending on the context in which the issue is arising.
So it was leading perfectly, I think, to the discussion about what we really want to talk about today. So the planes hit the buildings, an unbelievably horrible day. Congress reacts. John Ashcroft, then the Attorney General, announces a new paradigm and suggests that there should be a change in focus from punishment for proven crimes to prevention of terrorist acts. So Susan, I assume that really is kind of the genesis of what caused you to write your book. But I guess the first question is was Ashcroft right? Did he ask the right question?
Well, there are a lot of different subjects I cover in the book in terms of the prevention paradigm. You're absolutely right that in fact is a theme that follows a lot of the things that were done in the Patriot Act and beyond the Patriot Act. So one idea was, let's change the nature of criminal law. So instead of prosecuting people for things they have done, we're going to try to identify whether we think people might be at risk of supporting terrorists or whether they're doing things that create danger. And it's like a dragnet that you're kind of laying out more broadly. And then in the surveillance area, since we started with the Fourth Amendment, the idea was, well, the government should have more power to find out everything that everybody is doing and less judicial oversight and less need for particularized suspicion. So it seems to me, I'm understanding of what happened in the fall of 2001. It seems to me people were very panicky. We didn't yet know what it was that had happened on 9/11, so it was really hard to diagnose, to figure out what the antidote would be when we hadn't yet diagnosed the problem. So to me, some of the things that Congress did, the Patriot Act was passed 6 weeks after 9/11. There hadn't been any debates or hearings. And it has this kind of swaggering title that, do people know what the title is?
Tell us what the actual name of the
Okay, the actual name of the title. So you have to imagine that we have a PowerPoint up here that says USA Patriot, because that's not the name of the act. I'm going to tell you the name of the act. USA Patriot is an acronym. So USA Patriot. Uniting and strengthening America by providing appropriate tools required to intercept and obstruct terrorism. That's the name of the act. Okay, now the idea that Congress 6 weeks after 9/11 knew exactly what was required to intercept and obstruct terrorism, I think is a lot of wishful thinking. So, to me, the fact that the law went too far at that time is somewhat understandable. And what Congress did in some of the controversial provisions, perhaps some that we'll talk about, is they recognized that they were going out on a limb. They were giving the Department of Justice powers that it had been asking for years. People say, well, how did they come up with these things so hastily? They just said, okay, we're going to unleash you. You can do all those things you've been wanting to do. But what they did with 16 provisions was they provided sunsets, which meant that those provisions would expire after 4 years unless Congress decided to renew them. So what happened after 4 years, the first time everything came up for renewal, there were 1 or 2 provisions that were still controversial, the library provision, which we'll probably talk about later. But most of the provisions, Congress just said, oh, okay, we're going to make those things permanent. And there are all sorts of things that we started in motion in the fall of 2001 that we're still doing just because of inertia. And I can give you some examples later if you want, of things where I think we have reason to question whether we really are doing things that are effective, whether we're doing things that are cost-effective, both in terms of money and in terms of rights, and whether we're in fact doing some things that are counterproductive. So I think, the mindset of 2001 is one thing. 10 years later, one reason I wrote this book is I think it's about time that we had a serious conversation and included the American public more, because I think people really don't know a lot about the costs of what's been going on. So I understand what Attorney General Ashcroft wanted to do, but I think there hasn't been enough pushback and enough questioning of whether or not he really did set us off on the right path.
So, John, do you look at it the same way?
There are parts of that I do look at the same way. And a good example, right after 9/11, if you were to travel and wanted to check your luggage in at the curb, you were told that you couldn't do that anymore. Now, you think about why that particular restriction went into effect almost immediately. We had an old mindset of hijacking or a bombing of a plane, where you would check the baggage in and then not get on the plane, and it was easier to do that if you were checking the luggage before you checked into the flight, and so we banned the curbside check-ins. Except this group that had hit on 9/11 had already demonstrated they didn't mind being on the plane when they took it down. All right, so this ended up being more for show, that something was being done that had zero impact on what we were actually confronting, right? And part of the show is, and Susan has a great chapter in the book dealing with the New York subway backpack investigations. Part of the show is to put people at ease whether it has any particular impact or not, and there's a kind of a calming influence. And I do welcome the opportunity to challenge that, because we ought not to be doing things that are ineffective just for show. We want to be effective, but we don't want to be ridiculous about it. And so I think this inquiry is important. So that's our area of agreement. Now let me find the areas of disagreement, so you're not all disappointed. Because that would be boring, right? But the fact that we rushed into the Patriot Act, I think, is a little overstated. Many of these proposals have been around for a long time. In fact, many of the very provisions of the Patriot Act were already in effect in other areas of law enforcement. We were just not allowing them for terrorism enforcement, which is where they ought to be most allowed. So, for example, the notion that we've got material support things, and we had dropped the intent requirement on material support. Well, we've not had an intent requirement in environmental crimes and occupational safety and health crimes since the 1970s. The roving wiretaps have been something, as Susan pointed out, that had been available in drug enforcement, law enforcement side of the FBI house for quite some time. It was just not allowed in the foreign intelligence investigative side. And so one of the things it was doing is giving the tools to the people who needed them most, the same tools that had already been improved in much less dangerous circumstances. That seems like a sensible thing to do. So the fact that we didn't have hearings in specific about the Patriot Act between 9/11 and when it was signed 6 weeks later, I don't think means that we kind of rushed into this and adopted things we hadn't thought through. I think the terrorism investigation side for decades had been asking for tools that their compatriots on the other side of the building and had been using to good effect.
Actually, if I could make one comment, because I think the audience should be aware of the fact, because John and I are both going to be doing this, so you should be prepared. The Patriot Act, when I first printed it out, prints out at 300 pages. There are hundreds of amendments to previous law in all different areas. So John, of course, is an excellent advocate, is picking out the areas where the Patriot Act was helping terrorism investigations catch up with other areas like the roving wiretaps, many other areas where the Patriot Act says, let's do these things in terrorism investigations that we've never done anywhere else. Or where Congress said, oh, because we're so worried about terrorism investigation, let's just give the Department of Justice all this power and we won't even restrict it to terrorism investigations. So, for example, one of the things that they codified for the first time was this sneak and peek authority, that they gave the government permission not to have to tell people if they come into your house and search your computer, etc. They don't have to tell you, because that was one of the standards in the Fourth Amendment. The government always has to give you notice. Knock, knock, here we are with our search warrant, etc. So there was always some possibility in the court of maybe there would be a particular case where you could get an exception to that. But the Patriot Act codified that. Now, I can't tell you the figure off the top of my head, but I have it in my book. The sneak and peek warrants have been used overwhelmingly in drug cases, not in terrorism cases. So there are many, many examples we can pick from in the Patriot Act. And I just wanted to warn you that there's a very deep pool here. So we're both going to be picking our favorites, but there's plenty of fish in that barrel.
And I guess the question I assume others are going to be asking, and that I ask myself all the time, we've managed not to suffer, thank God, a really major attack. Who knows why that is? It could be great crime prevention. It could be luck. It could be some kind of know-how. But is there really any evidence that suggests that all these provisions, that at least arguably, Susan would argue, have some restriction on freedom, that they actually make us safer?
The evidence that was pieced together that led to the killing of Osama bin Laden earlier this year has its origin in two of the most controversial programs, the NSA surveillance program and the waterboarding of the three most high-profile enemy combatants that we had captured. Information that was gained in one of those interrogations took the investigators only so far. It required a matchup of the conversation where the nickname was then tied to the real name that led to the strain that identified the source, that pointed out who the messenger was that was revealing the messages, that helped us pinpoint the location. And those are the two most controversial, but that's the most publicly available information about the direct consequence. I do know that when the New York Times disclosed the existence of the NFA surveillance, that there's some rather dramatic evidence that our enemies switched their communications tactics in response to the disclosure of that. How much information we lost in the interim until we figured out what the new tactics were, I don't know. But we do know there was a rather dramatic shift in their communications tactics. You know, you go back to World War II, and one of the most interesting things about intelligence gathering is we had cracked the Japanese code. There was then a disclosure of that fact in the Chicago papers. And the U.S. government dropped the case, not because they didn't think they would win in trying to block that disclosure, but because apparently in a day before the internet, the fact that it was in the Chicago paper, the Japanese officials had not seen it, and they were afraid that if they highlighted by a lawsuit that the very thing we were trying to protect, which was not what the code was, but the very fact that we had broken it, would have been more likely to be disclosed. The existence of such a program itself, quite apart from the details and the uncertainty of what you can do and thinking you can communicate with impunity when in fact your enemy is listening in, those are rather dramatic things, particularly important, I think more important even in this war than in World War II, where we are fighting an asymmetric war, where the most important front in the battle is the information gathering front, because we can't defend ourselves with troops at every possible target they have. The information gathering is critically important, and the best way to respond to that asymmetric threat is with information.
So John, let me follow that up, because I know you've written and argued that in wartime, maybe the standard becomes different. Expectations of privacy become different. Imperatives about for public good, et cetera, become more significant. So I suspect that everyone in this room would agree that we're very likely in an unstoppable war if we define this in a war. This is a war that will go on for the rest of our lifetimes, the lifetimes of our children and grandchildren. Terrorism is a threat that we all live with every day. So does that mean, in your view, that the bar has moved kind of permanently?
No, it maybe, but I do think it's important to have the discussion about how the changed dynamic of this war means we should rethink about it. And one of the concerns I've had in the past, and I think Susan's book does a very good job at not overstating the case. Some of the books out there vastly overstate the case, and the prior administration did nothing legal, the entire 8 years, and you go on. Well, you look at the legal precedent for every step they took, and the constitutionality, and if you accept that we're in a war model rather than a criminal prosecution model, and that opened up avenues of action that might not have been open to you if we were in a criminal prosecution model, and that if this was a normal war, the things that were done were consistent with what Roosevelt did in World War II. In fact, much less onerous than many of the actions taken by Roosevelt or by Wilson or by Lincoln. You look at the great wartime presidents. And then we begin with the legality of that and then ask the question, how does the fact that this war is not something we see an endpoint to? There's nobody on the other side who's going to sign a treaty of peace that will call everybody to stand still. What does that do for the detention of combatants to keep them off of the battlefield, which was always perfectly legal under the old war model? Should we rethink that? But I think it's easier to have that discussion about how we rethink it if we accept the proposition that what was done heretofore is perfectly consistent with what we've done in the past. Then we can ask the question, how does this change dynamic of this current war force us to rethink what the old rules were, so that we can have a discussion? I think it's harder to have that discussion if we start off accusing people of violating the Constitution and doing everything illegal.
Yes, I guess part of the question is it really a war? But Susan, this is obviously an important issue.
I'm very troubled by the war metaphor. I think it takes us much further than we'd ever want to go for reasons that you're explaining, and perhaps later during the Q&A people may want to talk about Mr. Awlaki in addition to everything else. But one thing I want to comment on when John is talking about the Osama bin Laden. When the ACLU challenges the NSA surveillance and says that it's not constitutional, nobody ever claims that Osama bin Laden has constitutional rights or that you can't do surveillance on people overseas. What we're talking about are the rights of Americans in the United States, for the most part, or else we're talking about constitutional rights. I think the war metaphor, again, if we're talking about, the Supreme Court says, if we're talking about what we're doing in Afghanistan, where we're actually fighting, yes, the rules of war will apply, and you can detain people, you can do extreme surveillance. But as Paul is suggesting, I think if you say that we have a global war on terror and every place in this country is part of it, and therefore as American citizens, we should be subjected to the same kinds of government intervention in our lives, surveillance and everything else, as the Nazis would have been in Germany at the time. I just think that goes way too far, and I think this is a strong area of disagreement, because as John says, it depends which paradigm you start from. My paradigm is that most of terrorism really can be very well addressed through the criminal justice system. Now, in terms of John talking about what we know about the effectiveness of certain of the techniques, again, there are so many different techniques. So let me again warn you, John is going to pick the ones where he thinks there's the best evidence that they, in fact, produce something. And I have many examples I can give you where I think we were just on the wrong track always. And there are things that we should, like our terrorism financing laws. It was trying to solve a problem that did not exist, or it was at least wildly overblown. But on the ones that John was mentioning, I've read a lot of very contested facts, factual arguments about whether or not, in fact, the NSA surveillance really did help with the apprehension of Osama bin Laden. You can read, Google it. People have very different accounts of what was found and what was needed and what their alternatives might have been. Similarly, whether waterboarding has actually been useful or whether it's gotten in the way because so many people have given false information under torture. That's what Ali Soufan's current book is about, the former FBI agent. And that also is very much factually contested. But I think that, again, it's very difficult to assess because so much is happening behind the curtain. So the Inspector General of the Justice Department has on a number of occasions written reports on some of these provisions that Congress would finally say, oh, wait a minute, how is that being used? And the Inspector General has had a very difficult time coming up with any evidence that the NSA surveillance has actually been successful at intercepting or obstructing terrorism. The national security letters, there was a similar thing. The Inspector General did not come up with any evidence, except there's this one thing that he says, well, maybe in this case, black, 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 black. So we can't really evaluate that. So I think that the case has not been made. What the 9/11 Commission said 5 years ago is they said that because of political inertia, there's such a tendency of people to, politicians, to want to keep all the extraordinary powers they have. They want the power, and therefore it just keeps building, building, building. So they said instead of having our discussion now be framed as which of these provisions do we need to get rid of, they said the president should be required to defend retaining all of these provisions. So there are a lot of different things you would go through. Let me also, because I think a lot of the things that I say here are depressing. It's like this really is worse than you thought. Your constitutional rights are in danger, and no branch of the government is really being very helpful. So let me tell you about a panel I was on the other week with Rosa Brooks, who just spent the last few years at the Defense Department. And what she said, and she was saying that this was sort of what people say in high-flown national security expert circles. She said that 9/11 was really an astonishingly lucky event for the terrorists. She said that terrorism experts will tell you that for something like that to happen, every single thing has to break right for the terrorists, and every single thing has to break wrong for us. So even though the government obviously does not want to take anything for granted, and they are in the prevention mode and working very hard to try to apprehend or intercept or obstruct, what she was saying was that it really is incredibly unlikely that something like that would happen again. So I'm just passing that on. This is not my own wisdom. I don't claim to be a national security expert, but if that makes anyone feel better, that's a good thing.
I live down in the South Bay, right near the Long Beach, Los Angeles port, and for 10 years I've been very concerned that less than 1/10 of 1% of the cargo containers that come into that port have even a cursory inspection. The ability to get a small nuclear device or a biochemical device in one of those things that could have a devastating impact on not thousands of people that died on 9/11, but tens of thousands and even millions of people. Or take a dozen snipers and put them on bridges on the 405 freeway during rush hour. a couple of days of snipers taking out cars, we could shut this economy down pretty quickly. So because we're such an open society, we are vulnerable. Our water reservoirs are unbelievably vulnerable. And again, we cannot defend against every one of those soft targets without completely and dramatically altering the nature of our society, which means the gathering of intelligence to try and anticipate and prevent those is really the only viable front we have. And I want to talk about the secrecy question for a moment, because I do think there's a misunderstanding here. Being democratic and open doesn't mean not having secrets. Our Constitution itself builds in the notion, Article 1 has a provision that Congress itself, which is supposed to be, everything done in open, has a provision accepting such parts of its journal as in their judgment may require secrecy. I mean, it's right there in Article 1. Article 2, the very reason we have an executive created and fashioned in the way we do is the debilitating aspects of having Congress try and deliberate about war decisions that we suffered under the Articles of Confederation and the Continental Congress. And so we created an executive that was reported to a single individual rather than a committee, so you didn't have that deliberation, and that who could, as Hamilton says in Federalist 71, could operate with secrecy and dispatch when necessary to meet the right. I mean, that's the system we have. Now, we have a check on it on the front end, and hopefully with oversight in congressional committees to make sure. But Susan says at one point in the book that by keeping things secret demonstrates a fundamental paternalistic lack of faith in the American people. I don't think that at all. I think it demonstrates a real concern that because we're so open, things that we disclose to ourselves, we are also disclosing to the enemy, and that's the danger.
Okay, well, let me start with one area of agreement. What John is saying about the cargo ships, I think, is absolutely right. One chapter I have is all about, there's one expert, Bruce Schneier, who refers to all this stuff at the airports as security theater on the subways. That's okay, we're all taking off our shoes and nobody's paying attention to the cargo coming into the port of Long Beach. So, is that a good idea? Do you need massive surveillance of what books all of you are checking out of the library to figure that out? No, you don't. You could just have, checks of cargo, and there are a lot of things that we could be doing. In terms of the secrecy, however, here again, it's not an all or nothing proposition. Of course, some surveillance should be done. I'm not saying that we shouldn't have any surveillance. I'm just saying we should be doing the kind of thing that the Fourth Amendment provides and having some more oversight, because I think it's a tremendous danger in this country, and one that many of our framers foresaw, to put too much power in the executive branch without enough checks and balances from the courts and from Congress. So in the whole surveillance area, what the Patriot Act does and the NSA surveillance is they give the executive branch power to decide, who to spy on. And the courts have almost nothing to say about it, and Congress has not really bothered with much oversight. To me, that's a problem, and it's also an unnecessary problem. What John is saying is, we won't be safe if you can't do surveillance. I'm talking about process. I'm not talking about the government can't do surveillance. If the government had to go to the Foreign Intelligence Surveillance Court, which I know it's odd that they go to the Foreign Intelligence Surveillance Court, but that's where all this ended up, because the whole idea that the model that we were using for spying on the Soviet Union has become the model that the Patriot Act applies to all of us. But if the government did have to go to that court, does that mean that they wouldn't be able to find out any of the things they would wanted to find out? I have figures in my book. The Foreign Intelligence Surveillance Court approves applications in like 99% of cases. They virtually never say no to the government. But nevertheless, there's a point in having that check, because maybe it's just going to give somebody in the government pause if they want information for the wrong reason, if they're targeting political opponents or if they're going after people because of their religion. So it's not a question of can you do surveillance, it's a question of whether we're going to stick to the process of the Fourth Amendment and to the checks and balances. Has the government taken secrecy too far? I can tell you cases that I think are absolutely ridiculous. There's one case that the ACLU was litigating the constitutionality of national security letters, and the government argued that we were not permitted to say on our website that we had brought that lawsuit. They had this mosaic theory. Any slightest piece of information about anything we're doing, litigation techniques, anything, might help the enemy, and therefore you can't tell people. Obviously I'm not saying everything the government is doing should be transparent. Of course the government has to have some secrets, but I think it's been taken much too far, and we've been allowing that to happen.
So let me follow that up. So I expressed some skepticism less liberty made us safer. You said that the executive branch probably should be in a position where it has to, in effect, prove that it shouldn't roll back some of these extraordinary measures that have been made. One of the things that civil liberties advocates find frustrating currently is that this administration, an administration headed by a guy who was president of the Harvard Law Review, students taught at John Eastman's law school, obviously a progressive guy, has adopted many of the same positions of the prior administration. Is it? We don't really know what's going on behind the screen, as you say. Is it possible that he knows something that we don't know, and that there's actually a reason for his more plotting retrenchment on some of these techniques, approaches, et
it
cetera?
seems to me, again, we're talking about hundreds of different provisions. So, it may well be that there's, some case that we don't know about where something happened. We don't know. There's a lot happening behind the curtain. It's very difficult to believe that, in fact, there's secret information that the government has, that hundreds of different things that we're doing, some of which really look dubious to the experts, are all valuable. And it seems to me that a lot of people would like to assume that that's the explanation. Well, we want to trust the government, so it must be that we're doing everything right because we haven't been attacked. Well, it seems to me there are a lot of other explanations for why Barack Obama has taken the positions he's taking, and why his domestic anti-terrorism strategy is identical to George Bush's in most respects. He was trying to be different about Guantanamo and torture and the extra domestic stuff. Those are his first day executive orders. But as a candidate, he said no more national security letters spying on Americans without any court. That's un-American. And now as a candidate, he's arguing for more. Again, do we have any evidence that we know about that national security letters have helped with any investigation? No. How many times have they been used? Hundreds of thousands. Why does Barack Obama want this power? It seems to me the political inertia here is that people think that the president is going to keep us safe if we just give him enough power. The 9/11 Commission says any president should say to the American people, I can't guarantee your safety. This is an insecure world. Don't blame me if something happens. Maybe I'll do the best I can to prevent it, but I may not be able to. But I think that the blame game and the political inertia are that it would be political suicide for a president to give up powers that people think might help. And again, think of the dragnet metaphor. With all these very broad powers, is it possible that massive surveillance, massive preventive criminal law, massive security checks and everybody taking off their shoes, that it might prevent a terrorist act? It might. But it is in the nature of dragnets that you're also going to catch the unintended if you have too broad a dragnet. So nobody's saying the government shouldn't be allowed to do anything. What I'm saying is I think we should be rethinking some of this, and I think that the fact that Barack Obama has not changed the policies of George W. Bush is just not surprising. Jack Goldsmith, who was in the Department of Justice during everything, wrote a book called The Terror Presidency. As he says, Lincoln did the same thing. He suspended habeas corpus during wartime. Franklin Roosevelt was the one who tolerated the internment of the Japanese Americans. Clinton, we could go back to. Bush, Obama. I think it's in the nature of the presidency that you trust yourself with the dragnets. You wouldn't trust someone else. But once it's your power, of course you trust yourself. It's just natural human instinct to feel that you can be trusted. And even though the material support laws would let you prosecute the Red Cross, you're not going to prosecute the Red Cross. It's okay. You can have the power. And that's my analysis.
So John, should our friends on the Republican side of the aisle be comfortable that this president's gotten religion?
Well, I'm reminded of the story of the optimist and the pessimist, twin girls, and they come into a room, and the room is filled with manure. And the pessimist just thinks this is going to be a mess to clean up, and the optimist is just so excited because if with that much manure, there's got to be a pony in the room someplace. And the answer to that question kind of begins with the assumptions that we start with. If we begin with the assumption that the reason Bush sought and obtained and held on to so much power is he was power hungry, and that the office feeds that, and then our assumption that Obama, when he came into that office, is going to share those same sentiments, and we're going to get the request for more power, or at least the insistence that we keep the power. If we begin with the opposite assumption, that there's some really nasty stuff going on that are in those daily briefings, and that they are taking actions much more surgical than we've ever done in our history before. I mean, we have not whole-scale incarcerated Muslim Americans, for example, in the way that Roosevelt's administration did with Japanese Americans. Much more targeted in response to those daily briefings. If we begin with that assumption of what's going on, then candidate Obama criticizing it when he sees what's going on makes the same judgments. It ought to put us to ease that the fact that people of such vastly different ideological views from the get-go end up at the same position. And again, you know, is he welcomed the power and now wants to exercise it, or did he see the same thing that the prior administration did and react in an appropriate way? And I tend to fall on this. If people from the polar opposite ends of the ideological spectrum can end up doing the same things based on the same intelligence briefings that they're getting, I suspect that there's probably something there of legitimacy. I think Barack Obama is probably as more predisposed against taking those actions as almost anybody in the national political scene we might imagine now, and yet he's still taking them.
No, I don't think you conclude from that there's something, that there's a pony there. And that's exactly what you're saying. Like, there must be a pony there because he's doing it. It seems to me that the position that he's in, I never said that Bush was power hungry, and I think power hungry is the wrong metaphor. I think it is, understandable that the president wants all these powers, all the dragnets, all the prevention, and the power to find out anything at all, just in case, because they're going to trust themselves not to abuse the power. That's different from their power hungry and their venal. It's a different idea. Is anyone saying there aren't real dangers? No, but it seems to me that from the president's point of view, Jack Goldsmith describes in his book how the president begins every day being briefed by all the security people who say, okay, here are 6 dozen places in the world where things are happening and we have no idea if any of them are going to come to fruition, but they're all scary. I don't know if you recall, before Barack Obama's inauguration, there was a tip that somebody had that his inauguration was going to be disrupted by terrorists. So on his way to being inaugurated, he's working with the Bush security people about, oh my God, are they going to come? What's going to happen? It's his job to be nervous. Right? It's his job to worry. He said, one of the quotes I have from him is, first thing I worry about every morning is keeping the American people safe. Now, in that situation, when people are constantly barraging you with all these threats and tips and things that may or may not happen, most of them never come to anything, but it's very hard to analyze. What are you going to do? Are you going to say, well, I'm going to give up all the powers, or are you going to say, I'm keeping the powers just in case I ever want them? That doesn't mean they work. That doesn't mean there's a pony. And again, there are a number of powers where I could tell you there are serious doubts as to whether they were ever a good idea to begin with.
So Susan, one of the things I asked you earlier back in the green room is there something more fundamental afoot? I mean, is there a reason why this president is maybe more comfortable with the retention of these powers than he might have been a number of years ago? And I guess I think about 2 things yesterday. One, the death of Stephen Jobs. 2, young people in the streets in Lower Manhattan, downtown LA, and elsewhere. And the frustration is about jobs, the economy. I think in general their own frustrating circumstances. 40, 50 years ago, people were in the streets talking about civil rights and civil liberties. Today we have e-commerce, we have our banks data mining, we have cloud computing and all the rest. I mean, is our attitude about this fundamentally different? Are we more accepting of this? Has our world really been more changed by Barack Obama or by Mark Zuckerberg?
Well, I think
by Osama bin Laden or Mark Zuckerberg. Barack Obama.
Or all 3. Well, I think it's a very interesting sort of comparison in terms of what the president is doing. I think one part of the political equation is what I was just saying before. It's politically popular to look tough on terrorism, to say, oh, I have the answer. Do you remember when Omar Abdul Muttalib ended up, he was trying to blow up the plane, and President Obama said, oh, okay, here's what we're going to do to fix that. We have the fix. We're just going to do all these. We're going to put more people on the no-fly list, and then you'll all be safe. Well, probably not. But so I think part of the political equation is that that's what's politically popular. What you don't get much points for is, well, I want to retool as part of the Patriot Act to have less power for myself in order to save civil liberties. Where's the political benefit in doing that? Why is Obama not doing that? There's no political benefit. Plus, Congress isn't going to let him. They're going to fight back as they did with Guantanamo, as somebody pointed out. So where's the percentage in his doing it? It doesn't mean that it's all right. It just means, the politics just don't work because he's not hearing from the American people that we care about this for the reasons that that's the next part of your question.
And that's my point.
Right.
I mean, I'm kind of asking, is John right?
Right.
When John says maybe there's a different standard to be applied based on circumstances, is that where the American public is? Is that where most of the Congress is? Is that where most people really are these days?
Well,
there's a case pending at the Supreme Court right now dealing with police who attached a GPS tracker on somebody's car and followed him every place he went for a month. And I said, yes, I understand that's a problem. It may even be a physical taking as well as a problem under the Fourth Amendment. But I don't need to attach the tracker to the frame of the car. All I have to do is turn on my cell phone, and Bill Gates or somebody already has exactly the same information that the government was now seeking there. I can track my daughter's iPhone wherever she is right now, which is a good thing. She's only 16. I want to make sure. But the technological revolution that we've all witnessed over the last 20 years has made things much more visible to non-government actors. That's got to bleed over into the government having more access to that same information that the people we do business with has. And so it shouldn't come as a surprise we're seeing more of that. The question is it worth the trade-off for the additional technology for us? And I suppose I could get rid of my iPhone and go back to the dial ones, but I don't think I would do that.
I tell my 25-year-old the answer to that is no, but he doesn't listen to me.
Well, I think it's going to be very interesting to hear from the audience about this when we go to Q&A to see
Yep.
what people do think about privacy. Because I think, one reason I wrote this book is I think people are not aware of the extent of the surveillance, that there are these hundreds of thousands of national security letters, et cetera. And what's going on, I think, it's pretty amazing. But one question that a lot of people ask, which is sort of what you're saying, is why should I care if the government knows everything I'm doing if I'm not doing something wrong? And that sort of goes hand in hand with, we don't have any privacy anyway. It seems to me there's a fundamental difference between Amazon.com knowing what books you read and the government knowing what books you read. Amazon.com, in fact, has algorithms to figure out what book you're likely to read. It works, and they can predict you. We don't have algorithms to figure out if you read XX and X, are you going to be a terrorist. You might be reading the biography of Osama bin Laden because you just want to find out. So, it's not clear that we're going to get the same benefit from having that information that Amazon gets. Plus, last time I looked, Amazon cannot lock anybody up if you don't read the book they like. If the government knows everything about you, that gives them power. A lot of people talk about, the lack of privacy as Orwell. It's Big Brother is watching you. But I was quoting, I think it was Daniel Solov, who said the metaphor here is not Orwell, it's Kafka. It gives the government power over you. If you think in your own mind, just don't tell anybody, but think, have you ever done anything that the government might think was illegal or interesting? So, something that you just might be a little concerned that they found out, you would rather not have them know. And then you extrapolate from that. If you don't want the government to know what books you're reading in the library, you're not going to take out the biography of Osama bin Laden. If they can find out everything that your internet service provider knows about you, are you going to stop keeping things up on the cloud so that the internet service provider won't know and go back to Benjamin Franklin kept his records in paper on the drawer? It's just a tremendous power that the government has. John is absolutely right. You can't put the genie back in the bottle in terms of the government knowing things, because in addition to all the Patriot Act powers and everything else, which are direct government getting information about you from people who have it, they can buy information from data aggregators. They buy all sorts of information. So is that a good thing, or should we be trying to limit their retention of it and what they do with it, which is another whole question from can they get it? Because again, they just have all this information. It's not clear. We're spending, at this point, I just read the figure that we are spending more money on anti-terrorism, on national security than all the rest of the countries in the world combined. And a lot of this is this whole, the data aggregation and just, the Washington Post did a series last summer about all this, massive collection of information. And they referred to the government as drowning in data. We don't have enough people to look at all that data. They don't know what they're looking for, so they're collecting and collecting and collecting. And again, it's just not clear what we're getting out of it. One metaphor that I like that I read at one point was somebody said, if you're looking for a needle in a haystack, it doesn't help to add more hay.
John reacted. I'm going to have one more question, and I want to turn to the audience.
Yeah, no, look, I'm trying to stay in opposition here, but I agree. You know, but I agree with that. I'm concerned about the expansion of the digitalization of my medical records as part of the healthcare bill. I'll go back to the strict liability crimes on environmental and occupational safety, and the national security letters we're doing are very comparable to the just pull a empty subpoena out of your drawer that FBI and OSHA folks and everybody else have had authority for a long time in technical violation matters that are a whole lot less significant than the terrorism issues that we're dealing with, and yet we've been living with those since the 1970s. My guess is we would agree that we ought to roll that stuff back too, so that's not a rebuttal to you. I am concerned. I wouldn't, if we're going to have that stuff in place, I guess I'm less troubled by the fact that we've added the authority to deal with terrorism, which I see as a much bigger threat. I would like to unravel the whole lot of it a lot further.
So before we go to the audience, and because we have two experts on the stage, I have to ask you about something recent. You mentioned Anwar Awlaki. So a week ago, a U.S. citizen is killed by a predator drone in Yemen. No question about his terrorist connections, ties, sympathies, etc. My suspicion is the two of you may have a somewhat different perspective on this one. Susan, you first.
Okay. Well, after Mr. Awlaki was killed, there were a lot of, all of a sudden in the press, everyone was saying, "Oh, look at this! Isn't this controversial?" People have different opinions. Well, the ACLU had actually represented Mr. Awlaki's father, who was concerned that that the United States was targeting an American citizen, his son, and that we didn't know what the standards were. Now, this is something where I think it's easier if you're a lawyer to see the process problem as opposed to looking at the particular example. But our country is full of examples of horrible miscarriages of justice that happened because people thought they knew who had committed a crime. Lynchings and all sorts of things, they were absolutely sure, and they were wrong. And so it could be that Mr. Awlaki was actually, deserving of what happened to him. It could be that if we went through a very fair process that we would conclude that he had committed crimes, that he had gone too far to be protected by the First Amendment, and he had committed horrible crimes, and in fact maybe it was even appropriate to shoot him, as it sometimes is when the government is trying to arrest people for terrible crimes and the people refuse to be arrested. That could well be. I'm not arguing about the particular example. What upsets me is the lack of process. The fact that the president can just behind closed doors designate an American citizen worthy of being assassinated outside the country. Well, why not inside the country then? If we were in a global war on terror, could they just execute people in Santa Monica? And once you allow this, once we don't know what the standards are, what the criteria are, it is inevitable somewhere down the line that somebody who's not guilty of anything is going to be designated. Plus, we don't know what the government is doing to try to reduce collateral damage, civilian casualties. We don't know how broad this theater of war is, whether they actually would execute people in Paris or Barcelona. There's just too much we don't know here, which is my concern again. George W. Bush said in one immortal phrase, he said, "I'm the decider." But he's not the decider. We're the deciders, and we don't know how this policy is being made. So I really want to go bigger than, is this a bad guy? Probably he was a bad guy, but that doesn't mean that we can drop all our ideas of due process and just say this is a war. The Constitution has very specific ideas about how you would prove that a citizen has committed treason and is no longer to be treated like an American. So anyway, it's very troubling to me.
Let me start with the area of strongest disagreement.
I did, by the way, explain to John that he was in Santa Monica. So
Yeah. No, I have no illusions. That's right. If I can persuade 5 of you, I will. Look, my first area of disagreement is in the language of we don't know whether he was a criminal, what kind of criminal acts he took. We need a due process to do that. Again, that goes back to the original, the war metaphor. And I don't think it's a metaphor. I mean, what happened on 9/11 was not because there were a bunch of guys who were trying to get down to the basement of the trade towers to rob the bank. This was not a crime. This was an act of war against the United States. And Congress responded with an authorization for the use of force that is tantamount to a declaration of war. The declaration of war itself, the formal declaration of war, is not the only way in our history that Congress has recognized a state of war. And we are in a state of war. Now, what makes it a little bit different is it's not a state of war with a nation state, although there are certainly nation states that are providing support that we could name in that authorization for the use of force if we wanted to, for diplomatic and regional reasons over in the Middle East. We've chosen not to do that, and we've kind of come up with this euphemism instead, and I share your concerns about the euphemism. But the fact is, we're in a war with a group of people who are attempting and have succeeded rather dramatically and continue to attempt to attack us, to kill citizens, and to destroy our way of life. And it is a very serious war. And there are combatants on the other side that we don't treat as criminals, we treat as combatants. Now, we also treat a subset of them, and in this case, most of them or all of them, as unlawful combatants because the way they're conducting that war violates basic rules of the conduct of war and international law. So they're not just combatants, they're unlawful combatants. And that means that they can be shot on sight as spies behind enemy lines. Now, does the fact that some of them happen to be U.S. citizens alter that dynamic? The one Supreme Court precedent we have on this, dealing with German saboteurs and American citizens that came aboard, says no, they're combatants and they get treated the same whether they're a citizen or not. All right.
They didn't get shot in Quran. They got tried.
They got tried by a military commission, but having been captured on U.S. soil, if we were going to treat them as otherwise a citizen, we wouldn't have even been allowed to do that. So we already treated him differently than we would other non-combatant citizens. Now, so here's the real question, and I think it's an important one. Does the fact that our enemy has chosen to use tactics that are different than those that follow international norms or the rules of war mean that we have to be more solicitous of them rather than less solicitous if they were conducting a normal war? I think the answer to that has to be no. But it's an important question because it leaks over into domestic policy, which raises all sorts of concerns that we never had or rarely had in dealing with more normal enemies that we had in World War II, for example.
I'm going to let Susan respond, and then we're going to...
I just actually wanted to tell you one interesting thing in terms of perspective. One of the very interesting things that I've gotten to do because of my hat as ACLU president is I've been invited now for 3 years in a row to speak at the U.S. Army War College, where they have a National Security Week. And I was amazed the first year. They invited me to be the keynote speaker, and I was really kind of blown away. But after I got to know some of these people, these are all the colonels and the people who have been designated as being the leaders of the future, and the ones who are planning the war in Afghanistan. That's what they do. They're planning wars. So because I was there, they invited me to a breakout session that they were having, and this was last year, a little over a year ago. And they were talking about the targeted drone killings. And I can tell you that room was split right down the middle. Half of them were saying, well, it's a war. We have to have the power to, go where people are. And the other half were saying, what about civilian casualties? This is, there's no theater. We're not limited. Could it happen in Chicago? So it was fascinating to me that, that the debate was really replicated within that room. The military was very concerned. That I think also concerned that their voice was not being adequately considered by the policymakers.
But it's that very thing that has led to that norm in international law on the rules of war that make it illegal to engage in armed conflict in the manner in which our enemies in this war are doing, because of the concern to civilians. When you're running a traditional war with armies in uniform, the likelihood of confusion with civilians is minimal, although not non-existent. There's always collateral harm in even that. But when you engage in non-uniformed conduct of war, the threat to civilians is much greater, which is why the international law makes a big distinction between lawful armed combat and unlawful armed combat. The question is, when our enemies are engaged in the unlawful version of armed combat, which raises these risks, do we respond more aggressively or treat them with greater kit gloves than a lawful combat? And I don't think you can do that. You then encourage more of the problem that's created in the first place.
But part of the problem, following up on what John was saying, part of the problem of having an enemy that doesn't wear a uniform is it's a little hard to tell that they're the enemy. When the Nazi soldiers came on the subway, they didn't come in the subway. They came in the submarine. In the Quirin case, they came in their uniforms. They arrived in Nazi uniforms. When people aren't wearing uniforms, you can't always tell if they're the enemy. And having somebody just say, that's the enemy, without knowing what the process is. I'll stop.
We're in a difficult world. Somebody, Brian, you've got a mic?
Yeah.
So let's...
Just a couple of housekeeping notes before we start the Q&A, that we want to remind you to please ask a question and try to limit statements today. We have a very limited time this afternoon, and also there's only one microphone and one me today, so you have to be patient.
So maybe Brian, let's work you from the back over there. So let's start with that gentleman, back of the back.
Does the ACLU use the effectiveness of a policy to say we'd be willing to give up some liberties, the more effective it is, or, is there any judgment made as to where you think, or is it a fine line? We want to keep.
Is there kind of relativism?
Yeah.
Right?
How do you make the decisions as to where to draw the line? I think it's clear where he might, but it's not clear where you would draw the line.
I think there's always relativism in some ways. As John says, there's this word reasonable in the Fourth Amendment, and there has to be some play. Under the First Amendment, a lot of people have asked me about Mr. Awlaki. They say, well, if he's an American citizen, doesn't he have a First Amendment right to talk? And the First Amendment says only to a certain point. You can say whatever you want that's unpopular and hateful, but once you're really inciting immediate violence, you've lost your First Amendment rights. So yes, we do accept that there is always some sort of balance going on there. And again, there are so many things that we're potentially talking about, everything from sending in the targeted drone to detention to surveillance to prosecution, that I think we would have to get more specific about examples to talk about what kind of balance would be appropriate.
We have one more question on this side, and then
this question for the ACLU is with the consequences of failure being so severe with nuclear and biological weapons out there. Let's say you have a passive email or internet program that tracks keywords and whatnot, and you've got somebody with no probable cause, no one thinks this person's a threat, no one thinks this person's a terrorist, but they're emailing back and forth that they're going to detonate a nuke in Los Angeles. And the only way you would know that is by the government picking up random keywords. Isn't that, and I don't know, I shouldn't put words in your mouth, but is that worth the price of a nuke going off in downtown LA versus not picking up those keywords?
It's the same kind of relativism question, compromise based on facts. So.
Well, but there are a lot of assumptions, a lot of factual assumptions behind your question. Yeah. And what I was saying before is that there are a lot of experts who really question whether we have the algorithms to pick up useful words. So the whole idea that we're collecting all this information and that's going to make us safer. One of the things that we bought into starting in the fall of 2001 was, we have to give up some of our liberties to be safer. I think that in some of the areas we're talking about, not all, but in some of the areas, I think we're giving up liberties without being any safer. Because in fact, we've been sold the idea that the government is doing all these things which will keep us safe and it's going to be great just in case. But the just in case is just, it doesn't always work. The whole business of terrorism financing. We're not actually preventing anything. And we're doing, we're threatening a lot. Plus, again, there are a lot of distinctions because a lot of the NSA surveillance that's going on is not supposed to target American citizens. It's supposed to be people abroad, and that's fine. There's nothing wrong with that. We can pick up what Al Qaeda is saying to other rebels.
Wait, sir. We're gonna do this based on questions. John, do you want to just comment?
Yeah, I will agree to this extent. I do think government bureaucrats have a tendency to kind of carve out larger spaces for themselves. And we tend to be very bad at assessing the effectiveness of programs they put in place. That's true in this context. It's true over at the Department of Education. It's true at every department in Washington, D.C. And I would like to figure out a way where we could honestly, without the partisan political sniping that will inevitably go on, figure out a way to assess credibly, is this program really doing us any good? And if it's not, then even if it's a minor intrusion on civil liberties, it's not accomplishing anything, and we ought not to be doing it. I also understand in a large bureaucracy how hard it is to get to that point. So you've kind of got a bit of inertia that makes it hard. The problem is when you try and address it and you go overboard the other direction, I think one of the failures that led to 9/11 was an intelligence failure that some I don't know whether they're right or not because I'm not an inside the intelligence agencies guy, that some attribute all the way back to the exposure of CIA agents in the 1970s and the Church Commission. That cost us, live agents who were killed or exposed, that we then lost a generation of relationships that led to the most massive intelligence failure in our history. And so you've got to be careful with that pendulum swing. Even if something that looks relatively innocuous to give up can sometimes have collateral impacts because we swing the pendulum too far.
Right. Right. Next question. Let's go to this woman up here on the corner. That's fine. We'll get you next.
I'm a huge proponent of common sense, and unfortunately the law doesn't often take us there. So the ACLU made a whole lot of sense when we're talking about segregating libraries. It started to make a lot less sense when criminals who could break into somebody's home could then sue the owner of the home if they were injured. Nowadays, with terrorism,
What's your question? Go ahead.
with terrorism, when you've got a case where we have separation of church and state, but you can learn, the only religion you can learn about is Islam in schools, do you question that some of your ACLU policies have in fact been used by our enemies when that is the case? You can't mention Christianity or Judaism, but our kids can go and pray for Islam.
Okay, well, first, I think the factual premises of your questions are really not accurate. The ACLU has never taken the position that a burglar could sue somebody if he's injured, and there are no public schools where, in fact, Islam is taught and no other religion can be mentioned. If people have a private religious school, it's just like any other private school. There's no such thing in public school.
Let's move to the next question.
Yeah, moving on. I really appreciate the work that you've done. A lot of our civil liberties, a lot of our freedoms have been taken away because of 9/11, and there's an assumption that 9/11 was done by Muslim terrorists when that has never really been proven. And my question to you is, what do you think of how Building 7 came down? It wasn't hit by a plane. Building 7 came down 20 minutes after the planes went into those twin towers.
I'm going to interrupt. Let's move on to another question. We're not going to engage in discussion that has nothing to do with the topic that we're covering today. So, another question back there. We're not going to talk.
I was wondering if I can ask.
I don't think Susan's a construction expert.
I don't really know.
I'm curious to use your expertise just to extrapolate a little bit on Guantanamo. And, we talked about, and I'm right here.
There you are.
If you could just give us an idea, maybe just extrapolate a little bit, where we are, where we started, and where do you think, Guantanamo is going? Is it going to be closed or not? And kind of the legal implications of maybe the prisoners being there. Is there due process for them or not? There are probably individuals there that have been there for years without any trial. So I was wondering if, from the legal experts, what you thought about that.
Well, of course, it's a very big question. So as you know, at the high point, Guantanamo had, I think, about 750 detainees, and gradually over the years, most of them have been, in fact, shipped away to some other country or other. I think what's very concerning to me, and what I want to say about the question, because it's related to the themes that we discussed, there are so many things to talk about, is the whole fact that when we tried to dispense with due process in Guantanamo, when we tried to create Guantanamo as a land without law, and the president just got to say who was an enemy combatant and who should be locked up, we locked up a lot of people there for 7-8 years who were then released to other countries without any really finding out whether or not they had ever done anything to make it worth their being in Guantanamo. The Bush administration always conceded that there had to be people there by mistake. And when the Supreme Court ruled that the detainees in Guantanamo were entitled to go tell federal courts that they thought that they were being wrongfully held, the federal courts the federal district courts in a remarkably high percentage of cases looked at the government's evidence and said, that's all you have and you've been holding this person for 7 or 8 years. So to me, at that point, that was already supposed to be only the worst of the worst in Guantanamo. Are there bad people in Guantanamo? I'm sure there are. But to me, it's such a lesson about giving up due process and really trying to do things, without going through proper hearings and finding out what you have. Is it a bad thing if somebody's a terrorist? Do we want to detain them? Sure. But as I was saying before, you can't tell who's a terrorist until you've had the process. So I think that President Obama was trying to do the right thing by taking the people in Guantanamo and really giving them a trial. Let's figure out what they actually did according to our usual rules. There's a fascinating report by the International Commission of Jurists, which had a panel that went around for 3 years and talked to all sorts of countries about their reactions to terrorism, Argentina, Israel, all sorts of places, Ireland. And what they concluded was that most countries made a mistake when they dropped their usual criminal justice system and started changing the rules to respond to terrorism. And I think we've done too much of that. I think Guantanamo has really become an intractable problem.
John.
Yeah, I agree that the nature of this war with an indefinite endpoint makes it a problem that didn't exist in other wars. But I think we can honestly start a discussion about that problem only if we accept the proposition first that detaining combatants without a criminal trial is nothing out of the ordinary. Every war that we've been involved with, both our side and our enemy side, detain combatants, and you don't have a trial, you don't have access to the civilian courts, you don't even have access to a military commission to make the judgment whether you are properly there or not. If some poor schlup of a Swiss farmer is in the wrong place when Patton's going from France over to Germany and gets caught up and he's sent back to a POW camp back behind the lines, he stays there for the rest of the duration of the war.
He has a right to a hearing under the Geneva Conventions to see if he is a combatant.
Well, that's right. If there's any question, but there's no question that and the Geneva Conventions that made that right to a hearing come in after the World War II. So we now have, if it's an open question whether you were a combatant or not, you have a right to a hearing. If you're acknowledging that you're a member of Al Qaeda, there's no open question that you're a combatant, and in fact an unlawful combatant. And so there was no question we had the right to detain you without also bringing criminal charges against you that would prove the difference between combatant status and unlawful combatant status. We had the right to do that, but we weren't obligated to do that in order to keep detaining you. So there's nothing illegal that had went on up to that point. Now, run that forward 10 years from now, and for decades more, with the enemy being intractable in the way it is, should we change the model because of this new war? I think we can have a much more fruitful discussion about that if we accept that the people that have been involved thus far were following existing well-established international law and American law in detaining combatants. And then we can figure out, well, these combatants are different, and what does that difference mean as far as Guantanamo or any place else? And I think we could have a more fruitful discussion about it if we begin from the basic proposition that detaining combatants, again, it's the war model versus the criminal prosecution model, but I just don't see how you look at the events of 9/11 and say we're not in the middle of a war.
So we have time for one more question,
one more question.
and
Right.
this lady standing next to me has the question.
Apropos your discussion about unnecessary secrecy, what is your view of, and I ask this to both of you, what is your view of WikiLeaks?
WikiLeaks, yeah. I think WikiLeaks violated several statutes of the United States. I think the publication of some of that classified information also subjected the publishers to violations of those statutes. The Espionage Act, the relevant precedent we have is when the Chicago Tribune disclosed the fact that we had cracked the Japanese code. And there was no question at the time that violation could be criminally prosecuted. The only reason the government backed off was for fear of making matters worse, not better. And at some point, I think the failure to comply with classified information rules and the prohibitions against publishing them is going to need to be prosecuted.
Well, the ACLU has a sort of a complex position on this because we also don't believe that the government can never have its secrets. So I think it is permissible for the government, in fact, to prevent people from leaking all the government secrets. You can't tell people where the troops are going. There are some things that the government can keep secret. However, it's the Pentagon Papers all over again. If you have somebody who obtains information lawfully and then publishes it, and I'm a little concerned about President Obama using the Espionage Act so much more often than his predecessors. So Are we going to have closing statements or anything?
I think there are no closing statements. Before we thank our guests, I just want to again commend to all of you Susan's book, which is, by the way, for a book written by a law professor, very readable, very accessible. And among other things, you'll learn how Ted Kennedy and Nelson Mandela got onto the no-fly list,
and their pictures.
Which is a whole story.
If I could just say one thing on behalf of my publisher, my book doesn't cover Guantanamo and torture and all those things. That's my opening anecdote. It's only about ordinary Americans, and it's actually 90% of the book is about things that we didn't cover today: the impact on charities, on businesses, the material support laws, humanitarians. So there's pictures too. So I commend it to you, too.
So please join me in thanking Susan and
thank you, John. Thank you, Paul.
I never thought I could stay